not, the anti-gunners are still talking about 19th century surety laws out of places like Massachusetts to justify their modern restrictions on carrying guns outside the home, something that was settled by NYSRPA versus Bruen in the U.S. Supreme Court. Stay tuned. Let's talk about why these surety laws provide no support for the anti-gun position. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel or followed us on Twitter, please do so. Show your support for the Second Amendment and the Bill of Rights. Okay, folks, this is important. The anti-gunners in places like New Jersey and New York and beyond continue to talk about so-called surety laws. And I hate to have to talk about these again, but because these things keep raising their ugly head, we need to knock them down like whack-a-mole. And I want to make it clear why these are not relevant. I also want, in the context of doing so, talk about the Bruen decision specifically as to how to analyze these kinds of gun control laws in the modern context. So you get it right. Very important that we don't let the anti-gunners dupe us or dupe courts into doing the wrong thing by mistake. That's why I'm very aggressive on this channel of helping that everyone watches this get it right, not just for the courts, but the court of public opinion and beyond. Okay, to begin with, the anti-gunners are trying to restrict various types of carriage. They're trying to make it hard to get a license in certain places like New York and New Jersey, as you knew they would. They're also trying to define and fight over so-called sensitive places, which is a government-mandated gun-free zone. Now, the concept of surety laws keeps coming up. First of all, let me tell you why they come up. Go back to what the U.S. Supreme Court said in Bruen. They said that the only way a modern-day gun control law can be upheld is if you go back to the relevant time period, which is the founding of the United States, the founding of the Second Amendment, 1791, and that founding window, because that is the time period when you get the original understanding, the original public understanding of the Second Amendment. What did the people who wrote the Second Amendment intend? What did the people that adopted and ratified the Second Amendment intend? What did they understand the meaning to be and the scope to be? That's why you have to go back to that time period and not a later time period, because only at the time period when the people were alive that adopted this can we learn from what they thought was the confines, the scope, any restrictions on the right to keep and bear arms at that time. So, with that said, you go back to the time period and you ask yourself, is there a founding era gun control restriction of some sort that lasted really from the founding era up until now as a form of a long-standing tradition of regulating firearms in the United States? Now, this was not a passing comment by the U.S. Supreme Court. This was actually articulated in what's known as the court's holding. So I just want to briefly talk about that very quickly. When you read a judicial opinion in a case, there's three things it does as a general matter. Number one is it tells you who wins the argument, who wins the case, the plaintiff or the defendant, the pro 2A people or the government. Okay? So the first thing it does, it tells you who wins. In Bruen, obviously, the winning party, prevailing party in the Bruen Supreme Court decision was the pro 2A plaintiffs. The losing party was the state of New York. That's the first thing an opinion does. The second thing an opinion does is it provides the holding, H-O-L-D-I-N-G, and the holding is the actual decision it's rendered, its actual rationale specifically laid out as to what it's decided. So let me read the holding to you. This is very important for you Second Amendment advocates to understand, especially any lawyers, law clerks, judges interested in the topic, and so on. The holding of Bruen is crystal clear as to how this is going to go on. And this is very important, and you'll see why, to understand what the holding is. And I'm going to quote it to you because the Supreme Court said it better than anything I could say. And of course, you have to follow what they say because they're the Supreme Court. Here's what the Supreme Court says, quote, "In keeping with Heller, we hold," see what I'm saying? Hold. "We hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation, meaning the modern day regulation, must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. Period, close quote. Did you hear what I just said? The government must demonstrate that the regulation, meaning modern day gun control law that's being challenged, is consistent with this nation's historical tradition of firearm regulation. Now, regulation is very important to understand what that word means. A regulation is something that is legally enforceable. It is a law. Okay? Nation's historical tradition of firearm regulation. This is, again, those courts holding. That's why they wrote, quote, "We hold that," and continue on with what I just quoted to you. Now, the Supreme Court was so firm that this is how it has to be, and that the anti-gunners and the government defendants have to come forth with laws at the time of our founding, regulations that were binding on people at the time of the founding, that they actually reiterated this standard using slightly different words, but the same meaning. Elsewhere in the Bruen case, this is what the Supreme Court wrote, quote, "We reiterate," you hear what I'm saying? They actually repeat themselves. Quote, "We reiterate that the standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation, modern day gun control law, that's what it's referring to. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command." Period, close quote. So you see, in two separate places in Bruen, the Supreme Court talks about its holding the essence of the decision. And in both contexts, they talk about firearm regulations at the time of the founding and regulations today, meaning actual laws. This is very important because, of course, the anti-gunners have the burden to show that there is some sort of a binding law that existed at the time of our founding that specifically regulated what they're trying to regulate now with the same reasons for doing it and the same purpose behind it. Now, before we get into more details about the surety laws and why they're not applicable and don't support the anti-gun position, I want to just clarify one last point, which is I've already talked to you about the three things judicial opinions do. Number one, who wins the case or wins the issue. Number two, the holding, which is the essence of the case. That's the most important part of the case because it lays out the law for people to follow in the future. And the last part is called dicta, D-I-C-T-A. Dicta is basically the rest of the judicial opinion that's not essential to the holding, but it gives further clarification. So, for example, the Supreme Court in the Bruen case talked about sensitive places. Most of that is dicta, because they didn't have to deal with sensitive places in the Bruen case, so it wasn't essential to the holding because sensitive places was not really at issue, but they did to give guidance to future courts deciding these issues. They did give dicta and descriptions and discussions of the notion of sensitive places or government-mandated gun-free zones to give guidance for courts to follow in the future, not answering the questions, but again, giving suggestions and ideas, and that is what dicta is. Who wins the case is number one, the holding is number two, and dicta is kind of the rest of the decision, meaning stuff that's not essential for the holding, but helpful for future courts. Those are the three parts of judicial opinions for all intents and purposes. Now, let's turn back to the issue of surety laws. So the anti-gunners are trying to come forth now with laws restricting or regulating the carrying of firearms in public. They are having a very, very difficult time in doing this because at the time of our founding, Americans could carry firearms all across the country peaceably. There was no real debate about this. We've talked about, for example, in 1770, after a mass shooting where the British shot 11 Americans, 5 of whom died in Boston, in the Boston Massacre, there was a major trial about whether or not the British soldiers committed murder, and they were represented by none other than Founding Father John Adams, who in court specifically says, we all understand that in America, we weren't the United States yet, but in America and in Boston, Americans are allowed to carry arms for the purposes of peaceable self-defense, basically wherever they go, including in downtown Boston on State Street, I believe it was. So that was the heart of Boston at the time of the founding, and there was was no debate about this. So for the anti-gunners, they're desperately trying to find some historical restrictions on how and when you can carry, because obviously they don't want us to be able to carry guns. They don't want us to have guns at all. They especially don't want us to carry them out in public. They hate that idea, and they're very angry about this. But one of the things they keep coming back to are these surety laws. Sometimes you will see this referred to in academic literature as the Massachusetts model of surety laws, but these are simply absurd to the point where even the United States Supreme Court rejected these in the Bruen case. But let's talk about it just briefly. The way these surety laws work, and by the way, before I even tell you how they work, keep in mind that the first such surety law of what I'm describing here does not come into existence in the United States until, I believe, around 1836, which, as you know, is after the founding, because I labeled the end of the founding as July 4th, 1826, which is the date on which Thomas Jefferson and John Adams both passed away. Actually, James Madison lived, some more years after that. But by the time you get to, 1834, 1835, 1836, the founding generation had basically all passed away, and therefore the founding era is over. And this is again important because the way to understand the text and the history of the Second Amendment and the rest of the Bill of Rights is to try to understand what's known as the original public meaning or the original public understanding that our founders had. And of course, once they passed away, for all intents and purposes, you're not going to be able to learn much about them because they're no longer there to write, talk, or act on those things because they're no longer with us. And therefore, anything really after the founding period is too late to glean the original understanding of the text of the Second Amendment or the rest of the Bill of Rights. So the Massachusetts model, which is the surety law concept, does not occur until after the founding era has come and gone. So it's already too late in time, number one. But with that said, the anti-gunners are desperately trying to, grab anything they can because they're so desperate, and they go back to these surety laws. And the way the surety laws work makes no sense in terms of helping the anti-gunners out. Just to jog your memory, the way these surety laws worked in early America, not during the founding, they did not exist in the founding. I repeat, they did not exist in the founding era. They came after that in the 19th century. But the way they worked actually don't even help the anti-gunners. It helps our side. The way they worked was as following: that if you were sitting at home and you thought your neighbor down the street posed a threat to you, you could go to court. You could go to court, file a complaint, and say to the judge, my neighbor is a bad dude and I think he wants to kill me. I want him to post a bond before he can continue to carry guns in public because I fear him. There had to be a trial. You hear what I just said? This is not like a red flag law where a judge can just rubber stamp, talk to you, rubber stamp, and take the guy's guns. No. There had to be an actual trial with evidence that both sides proffer, meaning you and your neighbor would put forth the evidence. And let us assume, for the sake of argument, that a court did find in the state of Massachusetts in the 19th century that my neighbor was a bad dude and threatened me. Well, there would be a court finding of that at the trial, at the end of the trial, and the remedy was not that my neighbor lost his right to keep and bear arms, not that my neighbor could not carry guns. The order would say that my neighbor would have to post a peace bond or a surety or some sort of something along those lines, like a bail bond, something like that, to post. It was never very particularly big. And once he did that, he could continue to carry guns. So it wasn't even a restriction on carry. It was really a requirement to post a bond. Now, I also want to mention, by the way, that as far as I am aware, I am not aware of a single instance where the anti-gunners have been able to come up with a specific example of someone that went to trial, lost a trial, and had to post a bond. As far as I'm aware, maybe you'll correct me if I'm missing this, as far as I'm aware, there's no instance in American history, at least in Massachusetts or in the that time period of the 19th century, where someone actually was found dangerous and guilty to the point where they had to post a bond. So again, that's an example of, not only was the law maybe there, but it's unclear if it was enforced or ever really used because there's no evidence of anybody ever having to sort of post the bond. And mind you, I want to show you just the hypocrisy and the funniness here of how crazy it was. And just to show you further insanity of the anti-gun position taken in Bruen and beyond, remember, step back for a second, that in the Bruen case, the anti-gunners also argued that the 13th, 14th century statute of Northampton out of England prevented people from carrying guns all across the United States. They said that Massachusetts had adopted the statute of Northampton. This is a law from England that was enacted literally hundreds of years, I think, before the birth of William Shakespeare. And they said that in Massachusetts, during the founding, the statute of Northampton applied. In the Commonwealth of Massachusetts, people weren't allowed to carry. But here's the funniest thing. If you think about it for just 1 second, how terrible that argument is for the anti-gunners, how it actually blows up in their face. Because if you buy into the anti-gunner argument that the statute of Northampton barred Americans from being able to carry guns in public in, among other places, the state of Massachusetts, and then all of a sudden the state of Massachusetts enacts the Surety Law, think about it for a second. That means the only people in the state of Massachusetts at the time that would have the statute of Northampton applying and the Surety Laws applying, the only people that could carry guns were those that were found by a court to be so dangerous they had to post a bond because no one else would be allowed to carry under the statute of Northampton. And that just goes to show you the extent to which the anti-gun legal arguments, how extraordinary they really go and the lengths they go to try to win, because they really, the truth is, Americans we've been a gun culture, a private self-defense gun culture since before the American Revolution, and to suggest otherwise, I think is simply not historically justified or founded in any respect. Okay, so to wrap up, I want you to take away from this video, again, the holding of the Bruen decision is that there has to be historical analogs that constitute actual laws of some sort that were binding on Americans during the founding period. And the argument that the anti-gunners keep bringing up in various courts are these surety laws. Do not let them get away with this, because the surety laws simply do not support any restrictions on our ability to carry guns outside the home. And the Supreme Court has repeatedly said that the right to keep and bear arms, among other things, allows us to be ready with a firearm loaded and unlocked in case of or in anticipation of a confrontation where we may have to use it for self-defense. The Supreme Court is quite clear on that. I think the text of the Second Amendment is pretty obvious on this as well. So, hopefully the courts will see things our way. I got my fingers crossed. Obviously, some judges may, some judges may not. Only time will tell. Eventually, I suspect the Supreme Court will have to step back into this. But in the meantime, you're going to be smarter for this video, hopefully. And if you haven't subscribed to the Four Boxes Diner, please do so. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.